Good morning. My name is Bonnie Terry. I'm Director of Employee Relations for the Montgomery County Educational Service Center, and I'd like to welcome you to our October 8th Virtual Safety Council meeting. At this time, we'd like to have our introductions by Steve Roth of the BWC. Steve, welcome.
Thank you, Bonnie. Good to be with everyone this morning in this virtual world. Welcome. I have a couple BWC announcements. So for the latest information on COVID-19 in Ohio and Responsible Restart Ohio, please visit coronavirus.ohio.gov. The Ohio Bureau of Workers' Compensation's Board of Directors recently approved Governor Mike DeWine's proposal to send Ohio employers up to $1.5 billion in dividends to ease the impact of COVID-19 on Ohio's economy and business community. BWC will start sending checks to private and public employers in our system in late October after first applying the dividend to any unpaid balances. The dividend follows a similar dividend this past April. The dividend equals 100% of the premium employers paid in policy year 2019. As in prior years, the dividend is possible because of strong investment returns on employer premiums, a declining number of claims each year, and prudent fiscal management. Ohio Safety Congress will go virtual next year. Our annual Ohio Safety Congress and Expo will be an online-only event in 2021. Mark your calendars for March 10th and 11th. The event will feature dozens of learning sessions and a digital expo allowing participants to chat virtually with vendors about new and existing products and services. As always, the event is free for Ohio employers. We'll open up registration at ohiosafetycongress.com in January 2021. Public employers that participate in the Policy Activity Rebate Program, or PAR, have until November 30th to earn their 50% rebate up to that $2,000 limit. To earn the rebate, participants must complete 11 credits worth of activities chosen from the 33 available activities. Private employers have more time with the deadline of May 31st, 2021. Not a participant in the PAR program, for private employers, it's not too late to enroll. The enrollment period ends January 29th. For public employers, you should consider signing up next year. Learn more about the program or check your progress by visiting our website, bwc.ohio.gov. Your local BWC consultants, industrial hygienists, and ergonomists are available to perform virtual consultations to improve your workplace safety programs. If you have safety concerns or issues you'd like assistance with, please contact us. We're here to help. BWC's Division of Safety and Hygiene continues our series of free webinars covering a variety of workplace safety topics. Safety experts conduct these one-hour webinars each Tuesday at 11 a.m. The remaining October lineup includes on the 13th, the new BWC website and other online resources. And then on October 27th, we're going to have reducing injuries using ergonomic concepts. To register, visit bwc.ohio.gov and search for safety webinars. This month, we also started to deliver live online training classes. These virtual classes began just this past week, and the remaining October lineup consists of electrical safety in the workplace through insight and implementation at NFPA 70E, which is the arc flash standard, and that's going to be on October 14th. Lockout, tagout, and safety-related work practices will be on October 15th. We have job safety analysis on October 27th, and then developing a driver safety program on October 28th. These courses delivered using WebEx will be similar to the courses you may have attended in our training centers in the past. They will offer BWC program credits for those who need to earn credits for the various BWC discount programs. Registration is through the BWC Learning Center. If you have any questions on anything I just covered, feel free to reach out to me. Happy to help. And also, one of us, let's continue to stay safe and healthy and make good decisions while we're out and about, so we can get through all of this together. Our speaker this morning is no stranger to this Safety Council. Hunter Brill concentrates her legal practice in workers' compensation defense and employment law, representing and counseling employers. In addition to defending clients in the common pleas and appellate courts of Ohio and Indiana, she represents employers in front of the Ohio Bureau of Workers' Compensation and Industrial Commission. Jennifer has served as an adjunct professor at both the University of Dayton School of Law and Sinclair Community College. She serves as the co-chair for the Dayton Bar Association Workers' Compensation Committee and is on the board of trustees for Agape for Youth. Please join me in welcoming Jennifer Brill. Jennifer?
Good morning. Thank you very much. Thanks for having me today. This is a little different. It's a very fancy setup here. I love it. So bear with me. My name's Jen Brill. I've been practicing for about 16 years. I've been doing workers' compensation for all of that time. I represent employers like you across the state of Ohio and some in Indiana. So I wanted to talk to you today about drugs. My law partner and I, we love to talk about drugs. That's what we always say. And it's a hot topic right now because our marijuana law went into effect a few years ago, and we're really just starting to see the impact of it. So some of this is probably going to be a recap if you've seen our presentation before. I think it's always great to remind employers of what they should have for a drug policy, how they can use a drug policy in defending their workers' comp claims, but also to talk about the new law and how it impacts employers and what you need to be aware of. Now, one of the things we were hoping for and why we pushed this out was we were hoping to have a few more maybe court decisions to really see how this is going to play out in the workplace, but COVID. So it's been a little slower seeing that play out, and that's probably a good thing for most employers. So I don't have a ton of information on that, but I do have some maybe helpful tips and some real life experience to share with you. So let's get started. Now I have to warn you ahead of time, my law partner is our technology gal, so she makes these slides for me, and sometimes they do fun things and I don't even know they're going to do it. So here we go. In an average U.S. company, 15 to 17% of employees misuse substances. 38 to 50% of all workers' compensation claims are related to the use of alcohol or drugs. That's a really high number in my opinion. Drug-using employees are 5 times more likely to file a workers' compensation claim, and substance abusers use 3 times more health benefits and incur 300% higher medical costs. So it's important to stay on top of this. On average, employees with inappropriate substance abuse cost their employers $7,000 annually. So keeping that in mind, let's talk a little bit about the intoxication defense. If you've had a workers' compensation claim with a positive drug screen, then you're probably familiar with this. But one of the things and one of the reasons that my partner and I started doing these presentations about 10 years ago was the fact that a lot of employers don't really understand the intoxication defense. They feel like if they have an employee who tests positive for drugs or alcohol after an injury, their claim should be denied. And unfortunately, that's not really the case. So let's go through the intoxication defense so that you understand how it can be applied and what you actually need to defend it. So under Ohio Revised Code, it's a statutory defense. 412354, an injury is not compensable if the injury is proximately caused by the employee's intoxication or drug use. That proximately caused is a legal term, of course, but it's very, very important in this situation. You can't just have someone who tests positive. The intoxication, whether it's drugs or alcohol, has to be the actual cause of their injury. Employers should be aware that the Industrial Commission has strict requirements that must be met before a claim can be denied based on a positive drug test. So the best thing to do is prepare your defense before you even have an injury. So what do you need for that? Number one, you've got to give your employees written notice that their eligibility to receive workers' compensation benefits may be impacted if there is a positive post-accident drug test or the employee refuses to submit to a post-accident drug test. There are a couple ways to do that. You can post it in your office. You can also put it in your handbook. And this is a sample handbook policy. And I see so many employment policies and safety policies that don't include this information. So this one says, if an employee is injured on the job he or she may be required to complete a post-accident drug test, or alcohol test. If it is positive, or if they refuse to submit to a post-accident drug or alcohol test, that may affect the employee's eligibility to receive workers' compensation benefits. That's the language you need. So what is a positive drug test? We run into this a lot where employers will say, this person tested positive, and we get the drug test and it's not a qualifying positive test. So first of all, the test is positive if it was taken within 8 hours of the injury for alcohol, which makes sense, and 32 hours of the injury for drugs. And one of the problems we see a lot is someone will be injured, but they don't report it to the employer for a few days. And at that point, the employer sends them for a drug screen. Unfortunately, that's not going to work. We can't use that positive drug screen because it's not within the time frame after the injury. All right, so the other thing you've got to have is you've got to show the level. So there's got to be a specific amount of the drug or alcohol in their system at the time of the testing. We get tests all the time that'll just say positive. Well, when I go to a hearing and I send that to the hearing officer, they'll say, well, we don't know what their level was. How intoxicated were they? Is this residual? Or is it evidence that they were using drugs immediately before the incident? So that's very important, is to have that level, and it's required by the statute. Okay, this is step 2, is a step that hangs up a lot of employers. The test has to be qualifying, so it's got to be one of these 3 things. It's got to be given at the request of a police officer, which, how often do you have that? Sometimes you have it if there's a car accident and that's the cause of the injury, but rarely do you have a police officer on site. The other option is it's got to be given at the request of a licensed physician who is not employed by the employer. We don't see that very often either. Unless they're showing some signs at the hospital that make the doctor concerned that they're under the influence, we rarely see that. The one that we can most often use is the drug test was administered because the employer had reasonable suspicion that the employee may be intoxicated. So how do you show that? You've got to have something that someone saw. And most often when we use this, we use a statement from coworkers, a supervisor, an HR person, someone who saw the person right before or after they were injured and can testify essentially as to what they saw. So direct observation of drug or alcohol use. We don't have that, but occasionally I've had someone say after an injury, oh, I saw them out in the parking lot in their car drinking or whatever they were doing. Occasionally we'll have that. Possession or distribution. Another employee says, oh, they sell drugs out of their car. They were doing it at lunch. Physical symptoms such as slurred speech, dilated pupils, or an odor of alcohol or marijuana. That's what I see most often. Is I'll get a report when I'm investigating an injury. They'll say the coworker said that they were slurring their speech, or the coworker said they fell asleep on the job before this happened. Those are the most likely things that we see. A pattern of abnormal conduct. I don't see that often, but I have seen it occasionally where someone, and it's usually with prescription drugs, where they're abusing some sort of prescription drug, where we'll see it over a course of days or a course of weeks, that the employer develops some sort of suspicion. And repeat or flagrant violation of company safety rules. So I use this a lot, where I've got someone who I'm saying was intoxicated. I can't use a violation of a company rule against someone in a workers' comp claim. We can't use their own negligence. However, I can use it to show that they were intoxicated. So if one of your safety rules is they've got to wear gloves, they have safety gloves that they have to wear, and they weren't wearing them, or they didn't use some sort of safety mechanism that they always use, I can say, hey, they were intoxicated and they were just being careless, because we all know that carelessness is one of the effects of alcohol and drug use. All right, so if you can meet those requirements with a positive drug test that is qualifying, The Industrial Commission will likely, that's the key word there, find that the employee's intoxication or being under the influence of drugs was the proximate cause of the injury, and the injury will not be compensable under the workers' compensation system. But if you can't show the drug test was qualifying, the only other way that the Industrial Commission can deny the claim is if there is a medical report from a reviewing doctor that reviews the intoxication levels and determines that the employee's intoxication was a proximate cause of the injury. Now, we've used these before. We use them often. It's pretty clear if the cutoff level is 50 nanograms per milliliter and they're at 1,200 nanograms per milliliter. That's a pretty easy argument to say they were intoxicated, right? But we don't always have that. Sometimes it's 100, sometimes it's 200. They're not so far over that it's obvious. So we'll get a doctor to say, yes, at this level, they would have been intoxicated, and this is the impact it would have had on their motor skills, on their ability to think clearly, to make good decisions. We'll use a doctor's report for that. Okay, so what happens if I can prove these things? The burden then shifts to the employee to show that his or her intoxication was not the proximate cause of the injury. I have employers who have come to me before and they'll say, oh, I've got an employee who was injured, he tested positive, so we're not going to pay him workers' comp. Well, sometimes you just can't use the intoxication defense. If the employee is doing everything he should have been and a coworker drops a slab of concrete on him, it's probably not his fault, regardless of whether he was intoxicated or not. Unless I can show that he was in the wrong place at the wrong time, he wasn't doing something that he should have that would have prevented the injury. There are just some injuries that are out of their control, and it really wouldn't matter what they were doing. All right, so for the best chance to win an Industrial Commission hearing using the intoxication defense, first of all, we want to have our drug policy in our handbook, and we want to file a copy of that policy with the Industrial Commission. If I go to a hearing, I can't testify for you. So I can't say, oh yes, they have a drug and alcohol policy, and this is what it says, unless I have a copy of that policy. So make sure when you have an injury and you're alleging or you're trying to use the intoxication defense, you give your attorney or your third-party administrator a copy of that handbook page. You want to file a copy of the signed acknowledgement form with the Industrial Commission. I always recommend that my employers, when they have a new employee, have them sign off that they've received and they have read the handbook. That's very important because you'd be amazed at how many times in hearing I'll say, here's their policy, and the employee will say, I've never seen that policy. I don't know where it came from. File the drug test with the Industrial Commission and make sure that it was positive. So what does that mean? Make sure that it has the levels on it and we can show that it's above those threshold levels. Make sure your test is qualifying. Remember that time period we had? And remember, you've got to have one of those reasons. So reasonable suspicion, administered by a doctor, or at the request of a doctor, or at the request of law enforcement. If it's not qualifying, get a medical opinion to support intoxication and file it with the Industrial Commission. All right, so those are the basics. Are you ready to talk about medical marijuana? Here we go. I love it. I don't love the medical marijuana. I just like to talk about it. Let's be clear. All right. So this was updated. This is as of July. I know there are still some states with referendums on their ballots. So this is ever changing. Every time we give the presentation, there's something new. So all but 11 states have some sort of marijuana legalization in effect. And of those 11 states, a number of them have decriminalized marijuana. So it's not as scary. It's like getting a parking ticket or a speeding ticket. 29 states have legalized medical marijuana, and 12 states in DC have legalized recreational marijuana. So that's pretty much whatever you want to do with it right there. And this is as of July. Okay, so let's talk a little bit about marijuana in particular and how it impacts people and why it can impact your workforce. So the active chemicals in marijuana with medicinal applications. THC, that's the one we hear all about. It's the principal ingredient and it's got psychoactive properties. It generates the high. CBD, so we often hear this, the difference between CBD and THC, because we know CBD oil is pretty popular right now. It lacks nearly any psychoactive effects. It helps make the psychoactive effects of THC more tolerable, and it reduces the impact of anxiety and paranoia. So CBD, that oil, we see it used often. People will say that it helps them with their arthritis. It helps them with joint achiness, pain, that sort of thing, but it doesn't give them the high that the THC does. I love this guy. This is why we leave him in here. All right, let me back up a second. A few years ago, and it's probably been 5 or 6 years ago, we were at a workers' comp seminar, and there was a doctor and a lawyer who came in from Colorado. And this was back when Colorado was the only state who had legalized marijuana. And they had very interesting viewpoints on whether there is actually any medicinal benefit to marijuana. And one of the things the doctor said was it's really hard to judge because it has such differing impacts on people. For some people, they say it helps with anxiety. For some people, it helps with pain. We know that there are some benefits to cancer patients. We know there are certain strains that can help with seizures. And we see a lot of parents who have children with seizure disorders moving to a state where they can give their children medical marijuana because it's the only thing that helps with their seizures. So they had a very interesting take on it with respect to the medicinal benefits. And the doctor said, yes, there are some patients who I absolutely believe that it helps them with whatever their pain is. But he said, then you have the snowboarder who comes in and says, well, it's the only thing that helps. I wiped out and it's the only thing that helps my knee pain. He said, maybe we should take some Advil. So it's very questionable, and I think that's one of the reasons it's so taboo, is there's really no way to judge or quantify the medicinal benefits because it does have a different impact on everyone. So some of the things that he said that it does help and that we've seen studies on: pain control. So used with traditional pain medications to treat headaches, cancer, glaucoma, nerve pain, nausea and vomiting. This is what we see with cancer patients often. Appetite stimulation to wage against weight loss caused by chronic illness such as HIV or nerve pain. Muscle spasms, epilepsy, and seizure disorders. So these are some of the benefits. The side effects, because that's what we're really worried about, right? Dizziness, drowsiness, short-term memory loss, euphoria, although some people would say that's not a bad thing, anxiety and psychosis. So we really don't know how it's going to impact someone. Here's the problem with medical marijuana or any marijuana being legalized in a state. Under the federal regs, and I always say the feds, under the feds, marijuana is a Schedule I drug under the Controlled Substance Act. So these are drugs, the feds determined that they have no currently accepted medical use and a high potential for abuse. It's in the same category with heroin and LSD. It can't be prescribed, administered, or dispensed, and it's illegal to use, purchase, sell, or cultivate. Clearly, that's different than the state laws where they have legalized it. It's a Schedule II drug under Ohio's revised code. And these are drugs with a high potential for abuse, with use potentially leading to severe psychological or physical dependence. They're also considered dangerous, but it's similar to Vicodin or Adderall. So drugs that have been shown to have some medicinal benefit, and that's why it's a Schedule II drug. It can be legally prescribed by a doctor. I say prescribed. They're not actually prescriptions, but you'll see us say prescribed in this presentation. It's a referral. Ohio won't prosecute medical marijuana users, but there is no guarantee that they'll be free from federal prosecution. All right, so who regulates our medical marijuana laws? The Ohio Department of Commerce regulates the licensure of the cultivators, the processors, the labs, and the doctors, as well as the Ohio Board of Pharmacy. The State Medical Board of Ohio regulates the physician's requirements and procedures for applying for and maintaining certificates to recommend medical marijuana. They also maintain the list of conditions for which medical marijuana can be recommended. Now, I don't know you all, but if you were to take a guess at what kind of doctors are approved to prescribe, I'm going to use prescribe, but that's not really what it is, to refer people for medical marijuana, you would be surprised at the list. So there are podiatrists, there are regular family physicians, there are emergency room doctors. They're not just the traditional pain doctors, which I think when this came out, a lot of people thought, oh, it's going to be those pain docs. They're going to be the ones doing it. That's not the case. So our law, it was House Bill 523. It went into effect on September 8th of 2016. It limited legalization for medical marijuana only for qualifying conditions. And there are a number of listed qualifying conditions. And you see the one that's blinking, pain that is either chronic and severe or intractable. That's really, really, really broad. A lot of these doctors, especially with COVID, are doing Zoom visits with people to refer them for medical marijuana. They last about 20 to 30 minutes. They ask them about their pain. They ask them what they've done to try to help it. And then they give them a referral. All right. So what forms of medical marijuana can be used? Oils, tinctures, plant material, edibles, and patches. So a few questions. Can you vape it? Yep. Can you smoke it? No. Can you grow it? Not unless you're an approved grower or cultivator. So I've done some research on this, and I'm sure there are people who think I'm a stalker of some of these dispensaries, but it's very, very interesting to watch. So this isn't in the presentation, but I wanted to give you all some real life experience because I have stalked a few of these places. And from the outside, you would never know that they're a dispensary. They're very, I don't want to say incognito, but they don't say we sell weed here. Okay? People wait outside. And I think I've told you all before, if you've heard my presentation, when we were in Las Vegas, I went to one there to see what it was like. And it was more like a store. It was very clean. The employees were salespeople, but they had security. I haven't been able to go into one in Ohio, but I have stalked them from the outside. You actually have to be one of the people with a referral to go in right now with COVID. So I sat outside one day for about, I would say 45 minutes, because I wanted to see what kind of people are going in and out. Well, because of COVID, everyone has to wait outside until it's their turn. So I got a pretty good view of the types of people. If you think that this is not in your workforce, I can tell you that you are wrong. There was no qualification with respect to the types of people, whether it was age, sex, race, none of that. You saw everything there. I believe, I don't know, but it appeared that there were a couple cancer patients in line. Young people, older people. There were people who were there in their construction shirts, which I thought was very interesting. I don't know that that's how I would do it. People dressed up. There was someone in a suit there. And we went and stood outside for, it was about maybe, I want to say between like 4:30 and 5:30 in the afternoon. So people were getting off work. And I thought that was very interesting. They had a person in scrubs. I don't know if they were nurses. I'm not sure. They were in scrubs, but they were very professional. They came out, they took people's names, they took them in one by one. But what I'm trying to tell you is it's a very professionally run industry. It has to be. It's highly regulated. The referrals that the doctors give are really like prescriptions. You get a certain amount that you can purchase during a 45-day time period. And if you use too much of it, then you don't get any more until that 45 days is up. just like a prescription. But what I will tell you in looking at how much they give you a daily dose, and you can buy however much you want within your prescription. But the daily dose, if you saw it, I thought, goodness gracious, that person cannot accomplish anything if they use all of that daily dose in one day. So it is a lot that the doctors are allowed to refer. And this screen in particular that says, can you vape it or can you smoke it? It comes in one form. You could vape it or smoke it if you wanted to. So there's no, they only give it in a certain form that you have to vape it. You have to take the oil. That's not how it works. It's very, very interesting. All right. So how do you get a medical marijuana card? I mentioned before that a lot of the doctors are doing it by Zoom. All medical marijuana patients and their caregivers are required to register with the State Board of Pharmacy. That's not a list that's going to be shared publicly. Okay, so people will say, well, I don't know if I want to do that because it's going to be shared. It's not public. The law prohibits the Board of Pharmacy and licensed dispensaries from making personal identifying information public. Physicians and those employed by dispensaries are able to verify registration from that list, and it's valid for 1 year. So who can issue these prescriptions? I mentioned before that we see all different types of doctors who are prescribing. They've got to be active, they've got to be an MD or a DO, and they've got to have active license with the State Medical Board of Ohio. They've got to get a certificate to recommend medical marijuana from the State Medical Board. And they have to complete at least 2 hours of continuing medical education that will assist in diagnosing qualifying conditions. It's not very much, right? Especially when you think this is a podiatrist or this is a family doctor, and they're taking 2 hours of training on it. Currently, there are over 600 doctors in Ohio, and I know that number is higher now. If you were to do a search in the Dayton area, I bet you would probably find 30 to 40 doctors. I know this is a shock, but there are some in Centerville. All right, here's where it gets tough for employers and for law enforcement. The drugged driving threshold levels. For marijuana, in urine, it's 10 nanograms per milliliter, and in blood, it's 2 nanograms per milliliter. The problem is this. It can stay in your system for days, for weeks, for months, depending on how often you use it. So if you are pulled over, it's tough for the police officer to use levels to give you a ticket. They're more likely to give you the ticket based on their observations. Okay, so I mentioned before, don't doubt that these people are in your workforce. So how are you going to deal with that? And that's really kind of up to you. The new law does not prohibit an employer from refusing to hire, fire, or take adverse employment action against an employee who uses, possesses, or distributes medical marijuana. And that's a question that I get often. Do I have to let them use medical marijuana? No, you don't. Nothing in the law requires an employer to accommodate an employee's use of medical marijuana. So if you have a drug-free workplace policy, that's okay. You can still have that, and you can still say, you can't use marijuana in my workplace. So should I continue to employ individuals who use medical marijuana? Again, this is up to you, and it really depends on your workplace and the safety precautions that need to be taken there. If you are a heavy industrial shop, you're probably going to need more safety precautions than an office building. So should you continue to employ them? Sure, but it's a slippery slope. Employers who employ marijuana users expose themselves to risk that they may not otherwise have, especially if you're one of those office people and you have somebody trip and fall because they're intoxicated. Examine the job duties of the individual to make sure that the employee is not in a safety-sensitive position. This is the kicker right here. You still have to treat all similarly situated employees the same. You can't discriminate based upon age, race, gender, or any protected class. That doesn't mean that all employees have to be treated the same. So it's okay to say your clerical staff can use medical marijuana, but your delivery drivers can't. And that makes sense, right? Your delivery drivers are out on the road. You don't want them vaping their medical marijuana and then driving your truck and hitting someone. But your clerical people, it might be okay if they're just typing entries in a computer. Who needs to maintain a drug-free workplace? Some of you have to have a drug-free workplace, even if the state says it's okay. So if you're a federal contractor, you receive federal funds, or you employ workers in federal safety-sensitive positions. Because remember, the feds still say it's a Schedule I drug, so it's bad under the federal regulations. You also have to maintain a drug-free workplace if you receive workers' compensation insurance rebates for having a drug-free workplace from the BWC. So, everybody else has choices. The law doesn't require or prohibit an employer to accommodate an employee's medical marijuana use. So the first option is to have a drug-free workplace. You can continue with your drug testing and your zero-tolerance drug-free workplace programs. Employees who are discharged for violation of the policies may be ineligible for unemployment or workers' comp benefits. But be careful, if you take an adverse employment action against a medical marijuana user, depending on the circumstances, it could be seen as an adverse employment action based on the underlying disability, which is prohibited under Ohio law. See, that law partner of mine, she's so witty. Option 2, drug test and then decide. You can test your employees for drugs and treat a positive marijuana result like any other positive drug test. Treat it like finding any other prescription on a drug test. The prescription is a recommendation. Decide whether an accommodation can be made for that treatment. Now, I have employers who, because of the safety sensitive nature of their business, they have provisions in their handbooks that talk about prescription medication, where if you are using something that impacts your ability to drive a car, to think clearly, to make good decisions, you have to let your employer know. You can treat it that way. That's okay because it does those things. Option 3, different strokes for different folks. You can have different testing and usage rules for different employment classifications. This is what we talked about. If you have people in safety sensitive positions, as well as those people who are non-safety sensitive employees, you can drug test the people in safety sensitive positions, but not the others. Okay. This I hear a lot, not quite as much anymore, but when people were going to Colorado to get their medical cards, and then they would bring it back here. So currently Ohio does not recognize medical marijuana registry cards issued in other states. The Board of Pharmacy has to attempt in good faith to negotiate and enter into reciprocity agreements with other states. I'm not sure if we have any of those so far. I'm guessing that as the states continue to legalize it, we'll see more reciprocity agreements. So what's the impact on the ADA? I mentioned before that there's a concern that if you fire someone based on or make an employment decision based on their use of medical marijuana, that you could open yourself up to lawsuits based on discrimination against their underlying disability. So the ADA actually requires that employers reasonably accommodate employees whose disability substantially limits a major life activity. It does not mean that the employee is entitled to their preferred accommodation. You are permitted to push back in circumstances where another reasonable accommodation is available, even if it is not the preferred accommodation. So how does that impact you? Do you have to let someone use medical marijuana because they say it helps them? No, you don't. This is the important part for workers' comp. We talked about the intoxication defense, and that's why I gave you the background on how do you use the intoxication defense in a workers' comp claim. Well, people were really worried, oh my gosh, now that it's a prescription, my employees are going to try to use this when they get hurt. Not the case. So there's really very little actual impact on using the intoxication defense or in workers' comp in general, based on the legality of medical marijuana. It doesn't adversely affect the drug-free safety program. We talked about that. This is really important. The BWC does not have to pay for medical marijuana after an injury. Only drugs that are approved by the FDA are covered by the BWC. And the BWC actually put out a policy statement when the law came about, and they said, we are not covering medical marijuana. It is not a listed drug that we would cover. It is not approved by the FDA. So we will not be covering it. Don't even try. BWC-funded prescriptions have to be dispensed by a registered pharmacist from an enrolled provider. And we know that the dispensaries are not pharmacies. Only prescriptions that are on the BWC pharmaceutical formulary are reimbursable. Again, medical marijuana is not on that list. So what are some of the things that you've got to worry about? Does bringing an injured worker back to the job present additional concerns if they're using medical marijuana? It kind of depends on your workplace and what are your particular safety issues. If so, is workplace safety as required by OSHA compromised? Something to keep in mind is that OSHA thing back there. What if you have a driver? What if state law says your driver can legally take medical marijuana, but the DOT regs and guidelines prohibit it? I would say don't do it. Don't let them come back. That's not good. All right, so some more issues. The proof problem. I talked a little bit about this with drugged driving. Is the presence of marijuana in the system what led to the accident, or was it something else? Marijuana can stay in a person's system anywhere from 24 hours to 30 days, depending on usage. That's a long time. If someone smokes marijuana and they are injured 30 days later, it's going to be hard to use that defense. And you'd be amazed what people say in workers' comp hearings. Anyone who's been to a hearing knows that people say all sorts of things. I've had people say, well, I didn't smoke it, but my son smoked it in our apartment. Okay. I've had people say, well, I didn't smoke marijuana a week before this, or any drug. They'll tell you that they used it 2 weeks before. So it may have been in their system, but they'll say, I wasn't intoxicated. It was 2 weeks before. I was on vacation. We were having a great time, and it's still in their system. So proving the impairment can be very difficult or sometimes even impossible. What can you do as an employer? Establish or update your drug-free workplace program. That first slide, well, it wasn't the first slide, but one of those first slides gave you an example of what you need to have to defend an injury based on the intoxication defense in your policy. So take a look at your handbook when you get back to the office, or if you're in the office, take a look at it today. Continue drug testing as part of your BWC program. This does not impact your ability to test people. The other option is stop drug testing. I don't advise that, but it's an option for you if you don't have a safety-sensitive workforce or workplace. Regardless of the path you choose, you need to review and update your policies and procedures often to ensure that you're in compliance. Have the basic language in there. Make sure that you're covered before an injury actually occurs. So are you ready for a little quiz? All right, do I have to allow employees to use medical marijuana in my workplace? No, you do not. Can I allow employees to use medical marijuana if I'm okay with it? Yep, absolutely. Can I prohibit the use of medical marijuana at work and outside of work? Yes, you can. So you can tell your employees, I don't care if you're off the clock or not, you don't get to do this. Does the ADA require me to allow employees to use medical marijuana as a reasonable accommodation? Nope, we cheated. We gave you the answer on that one. Should I review my company's drug policy with an attorney to consider the impact of medical marijuana? Yes, you should. And if you don't review it with an attorney, you at least need to have someone go back and look at it to make sure you have the language in there. The bottom line is that nothing has changed. This law may be out there, but nothing has changed. Okay? Thank you guys so much for tuning in today. I appreciate it. And go back and check your handbooks.